Any mention? Supplementary list, item number 1.
Yes.
Please, Your Lordships. So this is a writ appeal directed against the judgment passed by the learned single judge dated 17th of October.
Where did the file come?
Lordship, I'm sorry.
Yes.
Lordship, this is a writ appeal arising out of the impugned judgment and order passed by the learned single judge, Lordship, on 17th October 2024.
Yes, there's a caveat.
Yes, sir.
We have served the copy.
Caveat. You serve copy.
Yes, I
Yes. Seen the caveat. Caveat petition number 128/2024. Seen the caveat petition filed by the caveator, whose respondent in said appeal, represented by Mr. P.T. Sangma. Caveat stands discharged. Yes. Yes.
Lordship, here, Lordship, what had essentially happened is that in the year 2020, amidst the protests going on in Garhwal District Council, Lordship, the respondent here was the president of this non-gazetted employees association, which was an association for these, like the Lordship, the forefront of this strike.
What station was this?
This was in 2020 on, starting from 2020 onwards, Lordship,
Okay.
on various issues. Lordship, then during the COVID lockdown also, then what happened, Lordship, in the month of September 2020, the respondent was placed under suspension
20.
in September 2020.
Okay.
Thereafter, Lordship, he continued to agitate and create disturbances in the district council. And in fact, during the peak
Sit
COVID,
down, Mr. Sama. Make yourself comfortable. You can
During
reply
the-
to that.
peak COVID lockdown also, during the lockdown time also, Lordship, he gathered some 8 to 10 people and he staged a strike outside the district council.
So you mean he was the ringleader?
He was the ringleader, he was the president of that association, Lordship. Now thereafter, Lordship, now this protest happened on 22nd of July 2021 during the COVID time. Now on 30th July, Lordship, 2021, a show cause was issued to him separately because he was already placed under suspension. And 7 other persons who were there with him were also issued separate show cause notice as to why disciplinary action should not be taken against them. Now, Lordship, thereafter, all the 8 employees, including the respondent, filed a joint show cause reply on 1st of August.
Someone's talking outside, just you keep it down, sir.
On 1st of,
Yes.
1st of
Very
August,
disturbing.
Lordship,
Yes.
separate show cause was issued, but a joint reply was filed, whereby, Lordship, they basically said that they furthered their allegations against the district council, MDCs and all, Lordship. They did not make any amends. They said that we are not. They made allegations against the district council and the employees and the officers and the MDCs. Thereafter, Lordship, executive committee meeting was held on 5th August 2021, where this entire issue was taken up. Show cause notice was duly considered. And it was found, Lordship, that the respondent, who was already under suspension since 2020 September, continued to derail the smooth functioning of the district council, so he was terminated, Lordship. And the other 7 employees were placed under suspension and disciplinary inquiry was required to be held against them. Lordship, assailing his termination order passed on 6th August 2021, he approached this honourable court. And Lordship, by way of the impugned judgment, the learned single judge has set aside the termination
On what considerations?
on the ground that, Lordship, the Rule 9 of the Meghalaya Civil Service Conduct Rules has not been followed, and that the principle of natural justice has also been violated, as no DP was held for him, Lordship.
When was he appointed?
Lordship, he was appointed in 16th
He's a
January
regular
2013 as a temporary employment, Lordship.
Temporary employee, and why do you have to go for the disciplinary
Lordship,
proceedings?
so our grounds before the learned single judge were, Lordship, that firstly, his very appointment letter says that he is a purely temporary appointment.
Why do you drop proceedings?
No, we did not draw proceedings against him.
Why do you suspend him then?
Lordship, initially he was suspended because
How will you suspend him? If he's a temporary employee, there's no question of applying the same yardstick as the regular employees.
Lordship, no, here,
If he had created a problem, he's a temporary employee, throw him out.
he was suspended at that point of time, Lordship, with the expectation
So
that he
suspended
will.
means what? Suspension, means that you consider him a regular employee.
Lordship.
You suspend him and you drop. He said you should show cause, right?
We issued a show cause to him also, Lordship.
So you give him the trappings of all regular employment.
So our issue is not with our grievance here, Lordship, is that by way of the reinstatement, Lordship, at least we should have been given the liberty to initiate a fresh DP as per Rule 9, if that was the consideration,
Where's
Lordship.
the order?
Lordship will kindly have the certified copy of the orders.
I've not seen the file again. Yes.
Page 11, internal page 11, Lordship, of the judgment.
Yes. Yes.
Lordship, the internal page 11 of the judgment.
So what happened here is after the show cause, satisfied with show cause, he terminated him
We terminated him, Lordship,
without any proceedings.
without any disciplinary proceeding.
Although in the show cause, he had contemplated proceedings against him.
In the show cause, we stated that
Had he
we'll...
contemplated any proceedings against him?
Lordship will kindly have the show cause notice.
Yes.
Lordship, at page 44. I'm sorry. It's
See,
at
the last
page
paragraph, the authority GHDC is also directed written reply
Lordship.
should reach the undersigned within 72 hours with the receipt of notice, feeling
Lordship,
the matter
yes.
be taken up for consideration
Abide.
for appropriate legal listening action in your absence.
Lordship.
So after you got the show cause, you're not happy, you terminated him.
After he received the show cause, instead of replying to the show cause, he made a joint reply. And
What do you want today?
Lordship, my prayer is my prayer in this writ appeal is essentially, Lordship, that whether even if we are required to follow Rule 9 of the disciplinary rules, because that is what they had adopted in that resolution, we may be allowed to initiate the...
What's wrong with the order of the single judge?
Lordship,
Is there any patent illegality on the face of the record?
Lordship, the learned single judge said that Rule 9 ought to have been applicable in para 21 of the judgment.
Have you adopted this Rule 9? Have you
In that
adopted
resolution
this,
which was
this is an
that-
appeal, these are this applicable to the government servants, correct?
Lordship, yes. So now what had
Have you
happened
adopted these in district council?
in that resolution, which was in that executive meeting resolution, Lordship, there were 8 employees who were being considered. He was one of the employees.
No. Are these rules in vogue in the district council?
For the
when
other
will
7
conduct
employees.
district proceedings.
Lordship, what had happened? 8 employees were issued show cause notices. He was already under suspension. They all filed a joint reply. He was placed under termination. And for the other...
No.
For
These
the
rules
other-
which have been referred to in the order of the single judge,
Yes.
whether these rules are applicable to district council, Mega Services Discipline Appeal Rules 2011.
Lordship, by way of that same executive meeting decision, for the 7 employees who were placed under suspension, it was also further resolved that a disciplinary committee will be constituted for their for initiating
Under
DP
these
against
rules?
under these rules
Okay.
for those suspended employees. So that was the. But in toto, it is not applicable, Lordship. In district council, we don't.
So just a resolution from the committee that will follow these rules.
For the suspended employees.
That's only it applied to them,
Yes.
not to other employees.
Lordship, because normally they don't follow.
Can that be allowed?
That also, because that, in fact, all the 7 employees thereafter, they were all reinstated also without any.
No. Can that be allowed? Can you say for this a constitutional authority?
Definitely, Lordship.
Now you pass a resolution, suppose adopting some rules or to be used in some proceedings.
Lordship.
Can
It should
be
be
done-
adopted
can be
generally,
done
Lordship.
before notification that these rules have been adopted, and can you apply selectively?
No, Lordship,
Okay,
absolutely
for
not.
Mr. Sangma's client, will apply some other rules, and for the other employees, some other rules, different proceedings.
It should
We'll
not
apply
be, Lordship.
CCS for him, and
No, I understand, Lordship, because that was how the resolution was passed. But that
it's
also was not.
fraught with a lot of irregularities.
Some irregularities were there. So at this stage, Lordship, what we were Lordship, what is the main apprehension is that, Lordship, that he was the forerunner of this.
No, your main concern is that since he's a ringleader, so somehow he must be silenced.
It's not about, we'll issue the fresh DP,
So
we'll give him all the,
so
we'll follow this Rule 9, Lordship, we may be allowed to,
see, if you adopt something, you have to,
we'll follow it.
whatever it is, but he's a temporary employee. So anyway. Yes, Mr. P.T. Sangma.
Lordship, may I submit, Your Lordship, number one, my learned friend is saying that the JHDC has no service rule. To that, there is a notification where this says that this is the, of course, I have the Xerox copy. This is, my Lord, I'm sorry to have, but it's quite clear. They said that fundamental subsidiary rules and that Meghalaya fundamental subsidiary rules and subsidiary rules will be followed. That notification was on 28 January 2016. Since they don't have the separate rules, but then they have make the notification on 28 January 26 that till that. Yes. Now
That adoption came by this resolution only.
now, Lordship,
2016.
No, that 2021 executive meeting decision that they will adopt that Meghalaya Civil Service Conduct Rules.
now secondly, my Lord, as it is pointed out, because the show-cause notice, there was a general show-cause notice for all the 8 employees, including me. So now he said that I have not filed a separate show-cause notice. I have filed it. He has misled the court. He is in his affidavit, only in his the page this one 44 he has enclosed. I have filed a separate show-cause notice to the.
No, I don't understand what separate show cause.
Because
it means show cause reply.
Yes, show-cause reply, Lordship, show-cause reply. He said that I did not file. I filed a joint show-cause reply, but I filed it separate. So in the show-cause, the allegation against each person against me is the same. There is no separate allegation against me.
Are those other persons?
All
regular
other person-
appointees or all?
They're all
temporary appointees.
Temporary.
All of them.
All of them are temporary.
The nature of appointment against the other 7 employee and me, they are same. Allegation also is very. My Lord may kindly have the what is the allegation against all the 8 employees, my Lord. I will just like to read it, Lordship, because that allegation, Lordship, it is the same for all the things. May I take you to page?
Did the other people file writ petitions against the dismissal?
Because they will not dismiss.
They were not dismissed.
Or not dismissed?
They will not dismiss. They were suspended and they were reinstated. All of them were reinstated. Only me, I was terminated. Only on the same ground. The allegation was there that may I just read that the operative part. They said, whereas you have made a several the page 87. Whereas you have made a several fabricated, incorrect, degrading and defamatory statement and accusation against the administration and officers of GHDC during the said speech on 22 July 2021. This is the whole allegation, my Lord. This is the whole allegation. He stated, I have done all this protesting, rally.
What were you protesting about?
No, there was.
What were you protesting about?
Actually, there was some protest, not only me, but the whole GHDC.
What was your agitation?
That was not for non-payment of salary, Lordship. That was only there was a meeting, the general meeting.
Non-payment salary only.
Non-payment of salary only. Non-payment of salary, and not only the executive member of the NGA, but entire employee was there on 22nd July 2021.
Yes.
And that show-cause notice, Your Lordship, there's page 86. Page 86, my Lord.
You've seen that the show cause.
This is not to the respondent, Lordship. That is
Yes,
what I wanted.
the respondent one, Your Lordship, that
Respondent was issued a separate show cause. at
separate
page
on the same date, on the same allegation, Lordship.
That's 81.
Yes.
40, page 40.
No,
Page
80
40.
this is page, oh yeah, sorry.
Page 40.
Page 40.
His name is Nora.
Yes. Here also the allegation is same. The allegation against me here also of same. May I just read the same? Nothing. There's no change.
Okay, yes, fabricated and correct.
Yes.
Degenerating,
Same thing.
statement, accusation, imposition. Yes, because the facts is very clear.
Not even a single word.
Yes.
So now
So what do you think the court should do?
no, because here there is no irregularity and irregular with the order passed by the learned single bench, because the learned.
Can we say that the entire proceedings are, they're without any substance or without any basis because you are just a temporary employee?
No, Your Lordship, because we claim.
Or should we say that you are entitled to national justice?
Naturally, because the other 8%, other 7%, they were reinstated. There was not inquiry, even disciplinary.
Order of reinstatement.
Lordship, there is one page 90, one of the 1%
of this.
yes,
memo
page
please.
not no the type
91.
copy 92, Lordship.
91, 92.
Type copy.
Yes.
1%. The executive committee, Garuhes Autonomous Council, Tura, is pleased to reinstate Sri Hinibert Seth Marak, Forest Guard, Forest Department,
Because he just accompanied you, that's why he's reinstated.
No, all the 7 of them, all the 7. They were excluding, including there were 8 employees. They have issued a so-called notice. On the same date, only I was issued separate, but the allegation in the so-called is same with the other 8 employees. And they were all of them reinstated, except the private respondent.
Has been observed by the learned single judge?
Yes, everything was observed, Your Lordship.
No, part regarding the other.
Yes, Lordship. The judgment is there, Lordship. It was filed from the including. Was subjected to proper inquiry, and the consent committee come to binding on the necessity sending in government servant.
Where is the resolution adopting the Meghalaya discipline appeal rules?
Lordship, kindly have page 53. I'm sorry, the type copy, Lordship, begins at page 48 onwards. Type copy 48.
So you're working as LDA.
Lordship.
Page 48. This was the executive meeting held on 5th August 2021. Lordship will kindly have page 51. 51. Executive committee has directed to the newly constituted.
Does this need no notification to when it's going to take effect, or adaptation or
Para 6. My Lord.
No, there is no such separate notification. This was the only.
to make notification? Will this suffice to say the rules be applicable?
It should not, Lordship.
Is it adopted by the District Council in session or by the executive?
No, by the executive committee, and that too, it was specifically made for this, which was not proper.
No, it hasn't been done by the House.
No,
Of the House.
by the executive in this meeting
Such
itself.
matters.
In this meeting itself.
Strange.
Probably, Lordship, maybe.
Even if these rules are to be applied or not, the general principles
Of it has to be
applied. This one.
Para 6, my Lord, that learned single.
Then the disposal of his this writ appeal has been.
Lordship may grant us the
Yes.
liberty to hold a fresh DP, Lordship.
We'll record his submissions. Yes, this writ appeal has been preferred against the judgment and order
If
dated.
I may make one small prayer, Lordship. If I may take instruction from the District Council how they want to, whether they want to, Lordship, what they want to.
Okay.
We
yes.
are only praying for the liberty at this
Then
stage.
we'll
Lordship.
fix it for admission hearing and
Lordship,
next date and dispose of.
Lordship.
Yes, heard Mr. Dep Leonard Counsel for the appellant and also Mr. P.T. Sangma, who's present on behalf of the sole respondent, caveator stuff. We don't record anything. This the appeal is admitted for consideration on hearing the counsel. The appeal into consideration. This is matter after 1 week for admission hearing.
If I may pray for 2 weeks' time, Lordship.
Okay, 2 weeks. Oh, sorry. You're restricted for hearing after 2 weeks. Sorry. Thank you.
Obliged, Lordship.
Daily list item number 1.
It is both of neck in.
Lordship, we'll try to.
Please, Your Lordship. My Lord, I filed my affidavit to the condemnation application. The matter may be posted for hearing after 2 weeks, my Lord.
Where's the appellant? Mr. Abdul Jurwal, learned counsel for the respondent, submits an objection to the condemnation application. Please, the matter regarding the condemnation application be heard after 2 weeks.
2 weeks, my Lord.
As none appears with petitioner, just a matter of 2 weeks. Yes.
Obliged, Your Lordship.
Item number 2.
May I please, my lordships? Firstly, my apologies, my lordship, as I was on medical emergency leave, so I wasn't updated about the new protocol of availing the password link for the VC. So, my lordship, the arguing counsel is from Delhi. So, my lordship, my humble prayer, if could be excused for today, and a very short date may be fixed, my lordship.
You are MS Surana.
A. Surana, my lordship.
Yes, the thing is that last date, the senior counsel had submitted that the notification, notification 8/10/24 and circular 15 shall, it'll settle the matter. Is that correct?
My lordship, also as per what I have been briefed roughly by the conducting counsel from Delhi, he asked me to pray before this lordship that he wants to pray that the respondent should drop the matter as the issue has been resolved, my lordship. Moreover, the notifications.
Exactly. What notification is that, Dr. Muzira?
My lordships, if I may allow. Moreover, the circulars which were provided on the last date, my lordship, were not relevant with the matter which we are dealing. Instead of that, I have been provided with 3 circulars, my lordship. One is the Finance Act, one is the circular, and the other is the notification. If my lordship may allow, I would like to produce the same before this honorable court.
Yes, but then you're seeking adjournment at the same time.
My lordship, if this honorable court is gracious enough to provide an adjournment, then maybe a short date may be provided. So, a very short date, my lordship. Then on that, the conducting counsel shall argue the matter.
Okay. MS Israna, learned counsel petitioner, prays that the matter be adjourned due to the absence of the arguing counsel. So, not objected to by the learned DSGI. This matter after.
A short date,
2
my
weeks,
lordship.
yes.
Whatever.
Together, I'll count them.
Highly obliged, my lordships.
Hearing item number 4.
May it please, my lords. My lords, I'm seeking for some accommodation today in this matter.
Has this been admitted?
Lordships,
Lordship, yes. Where's Mr. Paul?
he's unavailable today, Lordship. He's out of station.
Okay, mentioned to me on behalf of the arguing counsel still not be available. Stop. Just a matter of 2 weeks, yes. Madam?
Obliged, Lord.
Obliged, Lordships.
Any mention?
Lordship, item number 21.
Yes.
I've taken consent after
number?
after a week, Lordship.
Item number?
28.
Who's the applicant? Why are you avoiding this matter? Who's the other side?
I have taken, he's here.
Here's the pundit. You have no objection?
No.
2 weeks.
Lordship, item number 40. Here the Honorable Court has given me chance to file a rejoinder in the meantime. So I have gone through the affidavit filed by them. The rejoinder is not necessary in this case.
Then we'll hear the matter today.
So Lordship, only after a week or can be taken up.
No objection. Promotion of the
Promotion
petitioner
because
to
the managing
headmaster.
committee said they have
School.
No urgency.
no urgency.
No urgency.
3 weeks.
Obliged.
Yes.
May I please, Your Lordship? Lordship, I beg to make a mention of item 36.
Yes.
My lord, I am the petitioner. I've been, on various occasions, I've been objecting to the.
Lordship,
I think this matter can be heard without MPSC also, my lord. I just need to point out 3 documents. Other counsels are here, my lord.
What are the cons?
I'm there for the private respondent. Let it come up because the
What's the matter
maintainability itself of the writ petition
Okay, we'll hear.
is in question.
My lord.
You just be here.
Yes.
If anything
If it's required, then
adverse
we'll
is
make.
required
Yes.
against MPSC, then we might adjourn it. Yes.
Lordship, I beg to make a mention of item 29, Lordship.
Where's Mr. Paul?
He's out of station, Lordship.
This matter deserves some closure. Yes. What to do?
Lordship, let it be, since Mr. Paul is not here, then let it be.
Well, next week might be a bit difficult. That was 18, right?
Then let it come,
Let it
Lordship, after.
December, let it come on 5th December.
Lordships.
Yes.
Obliged, Lordships.
Please, lordship. I beg to mention item number 37 and 39, lordship. I have informed to the parties, lordship.
You have gone to the
I have informed to the other party also.
37 and
I'm
37
in
and
39, Your Lordship, the state respondent.
why?
37, we have submitted some document. It is still under process. That it is regarding pension. They have asked to submit some document. We have submitted, and then whether we have received or not, that we are just waiting because they have asked some birth certificate and other certificate. We have just submitted to the office.
Yeah, sorry.
Lordship,
2 weeks.
lordship, 39, lordship.
37, 39.
Which are you submitting, 37?
37 we have submitted document. 39 also, lordship.
That's again okay.
Lordship.
Yes.
Much less, lordship.
Lordship, I beg to mention item number 35 of the main list, Lordship. I'm praying, Lordship, if this matter can come in next week, Lordship.
After vacations.
Next week, Lordship.
Why?
Lordship, some difficulty, Lordship. Learned senior is out of station, Lordship.
35.
35, Lordship.
You're not for the petitioner.
Respondent, we are for the, I'm for the respondent number 4 to 8, Lordship.
What's the matter about?
This is regarding selection process, Lordship.
We are challenging the appointment. No objection, Your Lordship.
Other respondents?
I'm appearing for respondent 11. State respondent, Your Lordship.
2 weeks, yes. Yes.
Much obliged.
Lordship, similar prayer for item number 31, Lordship. It's a joint prayer, Lordship.
Joint problem by Mr. Kami.
No, Lordship.
Lordship, learned senior, Philaman Nongburi, Mr. Philaman Nongburi is not here, Lordship. I'm told.
Any urgency?
Lordship, after 2 weeks, Lordship.
3 weeks, yes.
30 and 31 are connected from same.
3 weeks.
Lordship, similar prayer for item number 32 and 33.
Where's Mr. Nongri?
The conducting counsel is Mr. Papaski, Lordship.
32, 33. After 3 weeks, Your Lordship.
33?
32 and 33 are connected matters, Your Lordship.
Any urgency?
No, Your Lordship.
Then 3 weeks. Yes.
3 weeks, Your Lordship. Apply, Your Lordship.
Right, Your Lordship.
The next year there'll be in a different bench. These 22 matters.
May I please, Lordship? Your Lordship, I beg to mention item number 38, Your Lordship. I humbly pray that this matter be taken after 2 weeks, Your Lordship.
This one is pension matter. Actually, in the affidavit, they have clearly stated only gratuity is remaining. So there is nothing remain. The gratuity they have admitted. I also said it. Gratuity have not been paid to the petitioner.
Call Mr. Dear Mr. Deb.
Your Lordship, because Mr. SJ want to argue this matter, Your Lordship,
Why
he
you
want to
want
have
to argue it?
no, he want to make some submission, Your Lordship. So I humbly pray 2 weeks, Your
You get
Lordship.
through you get telephonic instructions. By the
Your
time the
Lordship.
matter is called out, you'll have what he wants to
I
say.
humbly pray, Your Lordship, for accommodation today,
You
Your
can be a
Lordship.
spokesperson if he's too busy to come.
We have some special difficulties, Your Lordship. 2 weeks, Your Lordship.
1 week, okay.
2 weeks, Your Lordship, because he will be
At the
out
meantime, I
station, Your
will be
Lordship.
just allowed to file one small affidavit.
What are you going to file on
No,
hearing?
this is the sanction, because sanction letter issued by the deputy committee. They have not disclosed in the affidavit, Lordship, because this is not clear. Because that's why I want to just file it, because this is as per this the affidavit, gratuity is around 17 lakh. So they in the affidavit they have stated that only gratuity is remaining. I'm also not disputing. But that type copy is not clear. I have type copy, but when I file it, then I can type it, and that is a sanction.
Yes, what remains in the case?
Nothing is remaining.
Yes, Your Lordship.
Para 7, they have admitted only gratuity is remaining, other due had been paid. So exactly in Para 7, they have stated we are not disputing that whatever money remaining, that amount they can release to the petitioner.
Yes. But the funds have not been placed. Mr. Deb, we'll close this matter. You've seen this order dated office order number 29.
Lordship, the matter was actually fixed for hearing because the petitioner claimed that he is entitled to the gratuity as per the previous notification.
No, he's not.
We are not saying
happy with
anything.
This one now.
We will have to take instruction.
See instructions?
Because Mr. Dey,
We are not claiming. I have already made a submission. They also make it clear in their affidavit, Lordship.
If we don't dispute the authenticity of the letter,
Yes.
then we'll close it.
This is the issue by the secretary to the executive committee.
No, this was long back in 2023. Thereafter, he came with 2 writ petitions saying.
No.
that it
This
should be
is
as
on
per the-
2000 on 3rd October 2024.
That's 24. Yes.
Yes, 2024. 3rd October 2024.
Let me taken up after 2 weeks, Lordship.
Pension matters is going to unnecessary. So this payments as per the
Let them just release that sanction which they have issued. We will not claim. We are not claiming for further anything. In their affidavit, they have categorically stated. They cannot deny also. In para 7 of their affidavit, they have make it very clear. It is their own affidavit only, where it says that revise and other benefit has been paid.
you receive other terminal benefits.
Yes, we have
All of
received.
them,
After filing of the after approaching before this government, during the pendency they have released. They have admitted also. We are also not disputing.
Where's Mr. Days?
Only
Is he here
gratuity
today?
is remaining.
Station, Lordship.
Why it has to be finished up in his presence?
Lordship, because the issue of which formula, because his prayer was to.
No, the
have
formula
it
is
as
not
per
bothered
the-
anymore because
We are not bothering.
after he got that 17 lakhs in his hand now.
If I may pray, Lordship, that letter may be taken on board. It may be placed after 2 weeks for disposal, Lordship.
You take instructions from him. We'll have it next week.
Kindly have it after 2
Yes,
weeks.
as Mr. P.T. Sangba submits that the
It is the 3rd October.
district council authorities, Mr. P.T. Sangba submits that as the district council authorities have by order number dated
Order dated 3rd October 2024. Then the
Sanction.
letter number 29, office order number
of
29.
Order number
29.
29 dated
Dated 3rd October 2024.
the 3rd October have sanctioned an amount of
The 17 lakh 90,000
19,000
90,000
90
883.
as responded to by so and so have sanctioned amount of so and so towards gratuity, nothing remains
Yes.
consideration in the instant writ application, and it plays same be closed. Stop. Mr. S. Deb, however, on behalf of respondents, prays that the matter be disposed of in presence of the standing counsel.
Lordship.
Up to 2 weeks, yes.
Authorised, Lordship.
Go to item 38. Yes.
Supplementary list item number 1.
May I please, Your Lordship? Your Lordship, this is a contempt matter, Your Lordship. Your Lordship,
Which order?
if you can come to page number 22, Your Lordship. Paragraph number 4, Your Lordship. On this submission, the writ petition is disposed of with a direction to the respondent number 1 to 5 to take immediate step for constituting and conducting the DPC for consideration of eligible candidates from the post of UDA to superintendent within 3 months times from the date of this order, Your Lordship. But till Your Lordship, they haven't responded.
Yes, MS and Raji, you should notice returnable 3 weeks. So to take a message 80 within 3 days. Yes. List also.
Much obliged, Lordship.
Item number 2.
Please, Your Lordship. In brief, Lordship. The respondent number 8 and the petitioners are husband and wife. Now, they've been married. 8, respondent number 8, and the petitioners are husband and wife. Now, in the year 2006, they got there was a divorce. There was a decree of divorce passed between them. However, the petitioner being aggrieved by that order, she had challenged it, and that decree of divorce was set aside. Now, that is not the main contention. What had happened was that recently, the respondent number 8, his voluntary retirement was approved. Now, the petitioner went to inquire because there was a maintenance case which is going on between the respondent number 8 and the petitioner. She found out from the department that the respondent number 8 had in fact submitted the decree of divorce which had already been set aside before the department, thereby misleading, which had already been set aside, thereby misleading the respondent authority, which are the employer of the respondent number 8, to approve the voluntary retirement on the basis of this misleading information. Now, this has come to light also by assets and liability, affidavit and assets and liability, which is a mandatory document to submit in the maintenance case, wherein the assets and liability, kindly come, Your Lordship, to page 39, Annexure 6.
Yes.
Can you see serial number 6, date of separation, the date of 17 May 2006, decree of divorce. This is a decree of divorce which has already been set aside.
This was submitted in which date?
This was submitted recently, this year, in the month of November, if I'm not mistaken. This is recently November.
Yes.
So again, also the petitioner was able to obtain the extract of the descriptive role, the service role, where it shows that the name of the spouse is someone else. That I would like to show, Your Lordship. Kindly come to page 17, Your Lordship. 16 and 17.
So he's remarried illegally, that means?
Yes, Your Lordship.
17.
The name of the wife here, Srimati Sabita Devi, as the wife in bracket. Can you see, Your Lordship?
Yes.
Married. This is not the petitioner.
But the date of birth, simply Sabita Devi.
So Samita Devi is not petitioner. Petitioner is Munia Devi.
Yes, Dr. Majika.
Other notices to go to
He's
the
only
husband
been
also.
VRS. Already allowed.
VRS he has gone, but the thing is that his retirement benefits has not been, his money and all has not been released. So I have a miscase to stop that. Yeah. In the meantime, pending this
You heard Mr.
petition.
S. Marpanda, counsel petitioner. You should notice Dr. Mozika's
For 1 to 6, my lord.
present excess of 1 to 6. Notices to go to other funds within 3 days, but they said 80 stuff. This is the matter on after 3 weeks for instructions or affidavit and for service report on the two respondents, 7 and 8. Yes, where's the missed case?
Missed case, Your Honor. It's there, Your Honor. Just a simple prayer, just to direct the respondent authority not to release the or disburse the pension benefits.
This is an application for directions to respondent authority. This is an application praying for directions to restrain the release or pension benefits of respondent by 8 pending disposal of the writ petition.
But in the missed case, my lord, because the public servant is still surviving, my lord. It's not a question of family pension that it will devolve on wife. So the petitioner has taken voluntary retirement.
If we take voluntary retirement, Dr. Mozika, by misleading and even regard his that role also he's given, he's misled you all to
But in my assumption, he may not be deprived, my lord. Now, whatever dispute the notice we issued him, it is not a case that the pension is being disbursed to the
whatever
wife,
it is, but this person, see, what has he done? Hasn't he gone and misled the authorities?
Well, it appears that it is ex parte ordered by the High Court, my lord.
But after following due process, which has already been recorded in that order.
You are not aware of the proceedings of the High Court?
But the notice, can you see the High Court order, which set aside that it's gone ex parte, but it's been recorded that due notice has been.
He never appeared also ever.
It appears, my lord. Page 18.
That means he's not aware also about the
But again,
decree being set aside.
whatever this, I'm going with this order, with clearly at the first paragraph itself, the first line itself.
Where's the order?
It's at page 18.
Yes.
The first two line itself, I have heard so-and-so is done accounts of the appealant, none appeared for the respondent despite due service of notice. Despite due service of notice.
Anyway, let them come and instruction after 3 weeks. And this case will take up consideration next year.
So at least a protection, because there's a possibility the money might be released and then I would be
affected. Money will be released, what Robert says correct. If he's not aware of the decree being set aside, is a good due process, then you still have, not that you without any, avenues for relief. You
still have a remedy.
Item number 3.
Raj.
My lord, this matter, petition is seeking lordship intervention because the headman of the village, he was elected 2014.
From where the village?
My lord, Mapatao village, Dry Chabong, Kairem Simship. From 2014 till today, he is not calling for any village Darbar. So petitioner and others requested him to summon the village Darbar so that the...
2014?
14, my lord, till date. And this applies to the Kairem chief also and district council. My lord, till date, he is not calling for any meeting.
Where's the request you've made?
My lord, page number page number 16, my lord.
Get some water.
Page number 30 or so.
Yes. So, you didn't district council
My lord.
aim?
Yes, my lord.
Then what does this aim do?
My lord, they are not doing anything.
You just catch,
Let notice go to respondent number 3 and 4. Because by now, so Lordship is aware, the Act, Khairam Sameship Act, received the assent of the governor, but yet to be published in the Gazette.
It's been published. I got a copy. But that day I've gone for that.
There's something wrong in the typographical error. That's what they said. They've sent it back. Because there, my lord, the definition of Dorbarshnong and all this is there. What is a Dorbarshnong?
You heard Mr. H.L. Sariso,
Yes.
the counsel assisted by Ms. M. Hajong. If you notice, Mr. P. Dingdol is the counsel with Mr. C. except on behalf of
1 and 2.
1 and 2. Then no issue 2. The other responds within 3 days. Just after 2 weeks.
Item number 4.
We are for 1.
May I please, Your Lordship. Your Lordship, here, Annexure 6, Your Lordship, page 18. Here, Your Lordship, the respondent number 2, Your Lordship, published advertisement, Your Lordship, calling for the post of Assistant Public Prosecutor, Your Lordship. So,
Annexure 6, page?
Page 18, Your Lordship.
1 second. Annexure 6, page. Yes.
And Your Lordship, here in para 2, Your Lordship, which is in page 19, Your Lordship,
Yes.
is laid down a condition of eligibility, Your Lordship, and qualification.
Yes.
Point number 1, Your Lordship, degree in law from a recognized university, preferable with not less than 3 years of experience and practice in prosecution in criminal cases in court. Point number 2, candidate with record of successful prosecution of criminal cases in court will be preferable, Your Lordship. So here, Your Lordship, the petitioner, as he has completed his LLB degree in 2012, Your Lordship, and he joined the District Bar Association in Silchar in 2014.
He joined
the District Association Bar, Your Lordship.
Where is he
In
practicing?
Silchar.
Yeah, the petitioner.
Yes,
In
sir.
Tura?
No, in Assam. Your Lordship. Till,
Assam?
yes. Since then, he has been practicing.
Is this the petition is open to everyone?
Yes,
It is
yes.
not permanent residents.
No, Your Lordship.
Citizens of
So
India.
since then, he has been practicing in the district and session judge in Silchar.
Whatever it is.
So being qualified, he applied for a post, Your Lordship, which is under unreserved category. So on being found suitable, he was called for a screening test. And the result of the screening test is page 20, Your Lordship, which he was qualified for personal interview.
So he was roll number?
Not sure, Your Lordship. I think 35, but not sure.
Okay,
So,
anyway.
yes, after that, Your Lordship, he went for a personal interview. And the result for the personal interview was in page 22, Your Lordship, where the petitioner name was not there, Your Lordship. So thereafter, Your Lordship, the petitioner came to learn that this respondent number 3, Your Lordship, he has no qualification, no experience at all, Your Lordship, as required by the advertisement, because he completed his LLB in 2023, Your Lordship. Until now, he has not even cleared the AIBE.
Where is that? Where you got it by RTI? Where is that to show?
Your Lordship, yeah, I have no document right now, Your Lordship, to show to prove
How do
that.
you know that?
But he came to learn that he has just passed last year, Your Lordship.
You should. There should be somewhere available.
So on being aggrieved by this, because the respondent has no experience at all, Your Lordship, and not even clear a all India bar examination.
Oh, where you said that in your petition?
Para 12, Your Lordship.
But how can we just go on here say he's not qualified?
Because in the advertisement it's very clear, Your Lordship, there.
No, how do you say he's not qualified? How do you know he's not qualified? He passed 23. You sure about that?
Yes, Your Lordship.
You know the person personally?
I do not know, but the petitioner know personally.
You know the person personally? Yes, Mr. Shulai.
This is your Lordship. Lordship, here too, he took part in the selection process, your Lordship.
No. It's very disturbing if a person who's unfit.
Lordship, where are the materials, your Lordship? Where are the materials that the private respondent is not qualified, your Lordship?
That is what. Anyway, he's qualified, the person selected.
But the result, he is the qualified person.
If he's got all the eligibility, he meets the criteria.
Your Lordship, regarding that, will take instructions.
Let me take instruction, yes, heard Mr. Dinyota. Because we can't, have any kind of nepotism happening.
Certainly.
And if you're going to appoint, a prosecutor, I mean, it is for the benefit of society that prosecutor is appointed.
Correct, Your Lord. True, Your
He
Lordship.
possesses the
Required
requisite
experience, qualification, whatever.
Not that he's participated in the selection and. Yes, heard Mr. D. Jota, Learned Counsel with the petitioner. If you notice, Mr. Andy Shrilan, AG. is
For one,
present.
Your Lordship.
It's also present, except for number 1. MS B.F. Karmalang, sorry, is there for, is present, except on behalf of number 2. That was issued to the respondent number 3. Stop. Within 3 days, yes. This is matter after 2 weeks, yes. For instructions were activated by respondent number 2.
All right.
Item number 5.
Lordship, may I please, Your Lordship? Lordship, we have executed the agreement yesterday itself. And the
Where's Dr. Mon?
Lordship, it has been filed by Your Lordship, we have filed it, the affidavit by way of affidavit, but there were certain objection by the registry. So we will rectify that objection during the course of the day and file it.
Yes,
Otherwise,
Mr. You obtained copies?
I'll obtain instruction, but this is
Your Lordship, the petitioner and the respondent have agreed
to share the term benefit. Is the first wife, second wife?
No, Your Lord. First wife.
Father and
Wife, my Lord. Your Lordship, the petitioner has relinquished
The government has CCS rules only, correct? But the CCS rule is very long, at least that's section 9, with regard to entitlements of pension. Even reading it, we so
the government by
confusing.
Hindu Succession Act also.
Yes.
But
Yes.
merely they're entering into a compromise may not be binding.
Your Lordship,
A deed of final settlement dated 18 November 2024 between the petitioner and
Respondent number 5, Lordship. 5
has been produced for this court, whereby the said parties have agreed to, they have resolved their differences with regard to the
Pension benefits, Lordship.
pension benefits and other benefits of the deceased employee. Stop. Dr. Mbozika, please allowed to obtain instructions on the same. Yeah. Praise allowed, yes. Just after 2 weeks.
Declare place.
Daily list item number 1.
You have to obtain instructions.
No, Your Lordship, we haven't
Then?
received. I'm praying for some time to take
Give you 1 day at time enough.
1 week, Your Lordship.
I have strong objections, my lord, in this case. There's no point to prolong this matter. We are nearing to the end of the term session of the school also. If managing committee can be formed now, they will not disturb the school functioning also, my lord.
Yes?
It will not disturb the functioning of the school if the managing committee can be constituted somehow in this year by the end of December.
What is the additional affidavit filed by you?
No, filed by the government, my lord.
What was then affidavit?
They have considered that the order which has been approved by them is not correct, not as according to the rules. Additional affidavit.
Filed by Abraham.
Lordship, yes. It's not in accordance with the rule, Your Lord. Because we have the RT Act, Your Lordship, and then we have made the rule under that portion of that Act, Your Lordship.
Then we'll close it.
Just to give some more time, Your Lordship.
Who's leading you in the case?
Sir Hangreso.
Who?
Sir Aso.
Well, he was here just now.
He was
Wait.
here, Your Lordship. He was coughing.
Yes, sir. He's not well.
Maybe due to that also.
Let it come
We'll the day after tomorrow.
day after tomorrow.
Not day after tomorrow, maybe tomorrow.
Tomorrow?
Tomorrow.
Tomorrow.
Tomorrow, my lord. Obliged, my lord.
as the learned senior arguing counsel is not will present this matter tomorrow.
Item number 3.
My lord, as per the last order, the petitioner was supposed to cover the instructions.
Your Lordship, the conducting counsel, Mr. M. Long, appears on legs before court number 1, Your Lordship. I pray if this matter may be taken up at the end of the board, Your Lordship.
It was there then.
Your Lordship,
in business normally.
My lords,
Yes,
that's already reflected in order dated 5/11.
Order dated 5/11/2024 and observed that in compliance orders of court, the police conducting its business normally. As such, there being no further violation of the court order, or there's no violation, contempt stands closed and disposed of. You can file a fresh case if you want.
Item number 4.
Well, respondent number 4 has not filed the affidavit, my lord.
Respondent number 4, Lordship. I'm praying for 1 week's time, Lordship.
What's the matter about?
Well, it is a salary matter, my lord. This is August 2020.
Respondent number 4, Lordship. Managing committee.
Managing committee.
Mr. Pandey is allowed 1 week further time to file affidavit. This is after.
All right.
5.
On behalf of respondent number 4.
May I please, Your Lordship? Your Lordship, I humbly pray for 2 weeks, further 2 weeks' time, Your Lordship, in this case.
How many times you asked?
With this, it will be 3 times, Your Lordship.
That's last opportunity. Last opportunity for the 2 weeks time allowed to the petitioner to file the general affidavit. Please, the after. You file it, otherwise no
6.
more would be allowed any further.
In this case, Your Lordship, we received the affidavit filed by the school managing committee.
What about number 4? You filed? Yes, Mr. Sati.
Your Lordship, in this case, as the affidavit filed by the, we have also received the affidavit filed by the government and plus the respondent number 4. So
You have received it?
we have received. We have
Have you
received.
received all the affidavits now?
Yes, yes, Your Lordship.
Then?
So, Your Lordship, since the state also and the managing committee have asked for re-advertisement, so we pray that Your Lordship to allow the writ petitioner to participate in the new proceeding of selection and plus this proceeding be scrapped out.
Your Lordship, there was some irregularity in the score sheets. They had replaced the original score sheet whereby another candidate had ranked first and replaced it by showing the petitioner as ranking first, which was not correct. Then, Your Lordship, the state has taken a stand that there should be a re-advertisement and a fresh recruitment process because of all these illegalities and irregularities. So now if my friend concedes that...
You are still of age or you're over
Yes, yes, Your Lordship.
Where's the affidavit?
Our affidavit was filed on 4th of November, Your Lordship.
Who's this one number 3?
The SDSU, Your Lordship, of Sora. The score sheets had been tampered with, which is why the petitioner was shown as ranking first.
But, Your Lordship, the petitioner here had become a victim of the proceeding because I am not aware of anything. But
how can we be victim when we not first? They made you first.
No, Your Lordship.
Actually, as per the instruction and filed affidavit, the SMC received information after the selection committee set for the interview that one of the interviewer came and exchanged the score sheet. So it was informed to the SMC, and SMC also duly intimated the office of the SEO and then
after it was
recommended the name.
course, there is no fault from the side of the petitioner.
At page 7, Your Lordship will see.
Of the additional affidavit.
Yes, Your Lordship, which was filed on 4th of November. Your Lordship will see that the person, Miss Bunkins Sheolang Khain, her total marks is 97.5. And Kraupatkar Riatam, the petitioner here, was only 96. And so he was ranking second all along, but when they replaced this score sheet, then they have shown that he is ranking first, whereas this lady, Bunkin Sheolang Khain, who was ranking first, has been shown as at number 2. And Your Lordship may also notice that only the marks of these two candidates were changed, Your Lordship. For whatever reason, so which is why, Your Lordship, the state insists that they should have a re-advertised.
No, it's here. That was 18 para 5.
They have also conceded there has been a replacement of the score sheets.
Yes, sir. Take down. The petitioner, being aggrieved with the cancellation of his appointment as assistant teacher. Which school is this?
St. Jude's.
St.
Jude's or Judah?
In St. John?
St. Judah, Your Lordship.
St. Judah, what school is it?
RCLP school.
RCLP school, Lighthiam Sora.
RCLP school? Where is it?
In Sora, Lighthiam Sora.
Lighthiam Sora. Is before this court. By the incident petition. By the incident petition. Stop. It has been submitted by the. Initially, it had been submitted by the counsel for the petitioner that the petitioner, having secured the first position in the selection process conducted on minute selection held, where were declared first. Which lecture? Which lecture is that?
20th June, I think. Huh?
It was a lecture in your written application where if you select the schools, it came first.
Your Lordship said.
It's not annexed it.
Selection
Where is that?
Annexure 8 or Annexure 4.
It's the appointment.
Yes.
At page 25 is the advertisement, Your Lordship.
You've not annexed that select list, you never got it.
No.
Annexure 3 at page 25 is the advertisement.
This was submitted by the non-counsel petitioner that the petitioner, on having secured the first position, had been appointed by the respondent number 4 on 11 June 2024. But however, the same was cancelled by order dated. Where is that?
20 June. Next year,
On 20th June 2024, Your Lordship, the government had not. approve the appointment.
Because of lack of qualification?
Lack of qualification. That was a misinterpretation, Your Lordship, by the government. We conceded to that in the first affidavit. Then thereafter we found that...
by order dated 20th June 2024. However, he submits it transpired that this was a misinterpretation, which was also conceded by the state respondents. Stop. However, he submits on a reappraisal of the matter, it was found that there was some irregularity in the selection process by which the person was selected, and has also fairly submitted that the writ petition is open to the early selection being scrapped and he be permitted to participate in the fresh selection process if the same is advertised, if the same is conducted. Next para MSD Yangi appearing for respondents number
1, 2, 3.
1, 2, and 3.
3 is
has also submitted that it is a fact that the irregularity in the selection process. The fact there was a grievous, serious irregularity in the selection process, and as much as the candidate who had scored higher marks than the writ petitioner had been overlooked for appointment to said post. And as such, he submits that in all fairness, fresh selection should be held. Stop. Next, Mr. P. Doctorate for 104 also concurs submissions of the learned councils and submits that the irregularity that had happened was due to one of the two members who had substituted the result
the original score sheets.
Who had substituted the original score sheet. He also praised that the early selection being vitiated, therefore, be scrapped, and the managing committee be allowed to float a fresh advertisement for recruitment to the said post. Having been a council for the parties and having the parties in view of the fact that all the councils have made the similar prayer with regard to the same process, the same is declared invalid and void, and the respondent number 4 is at liberty to float a fresh advertisement for said post. It's made clear that on such advertisement, the writ petitioner also will be allowed to participate in the fresh selection proceedings. Yes, with the next para, writ petitioner according stands dispose at close of this.
Item number 7.
Lordship, we have received the affidavit filed by respondent number 3 yesterday, Lordship. I am praying for filing a rejoinder, Lordship, to the affidavit filed by them.
So, term order to be vacated?
No, Lordship.
So, rejoinder may not be necessary. A coordinate bench has decided the same issue in a different matter. We've enclosed a copy of the order as well.
It is not per se similar, Lordship. Here,
identical, my lord. In fact, she is a signatory to the objection in that case.
Which case? It's by number 3.
Kindly have page 11 of my affidavit.
Yes.
So there were a total of 90 petitioners, and Lordships will find that there are a lot of entries which says struck off by order dated so and so. These are the petitioners who had received their compensation. So they were struck off by different orders. Now, so she's not a party to this particular proceeding, but the subject matter of this proceeding was whether challenge was made to the legality of the Section 11 and the Section 19 notification. This was premised upon an objection which was filed by these people under Section 15. The court examined that and found that the Section 15 objection had not been filed in accordance with Section 15. So that's the same case here. They have not challenged any of the notifications. None of the notifications have been challenged till today. All they are challenging is an eviction notice. So the entire proceedings have already concluded. Nothing remains at this stage, my lord.
Yes.
May it please, Your Lordship. Lordship, what my learned friend is referring to in page 11, here the petitioners before the Honorable Court were totally different. I am not part of that proceeding, nor am I one of the petitioners who have been struck off in that? So that has no relevance to my case at all, Your Lordship.
Yes.
What is under challenge in this writ petition is a notice asking us to vacate
Okay, you
our
come,
land,
we'll have it after
without
1
you-
week.
Lordship.
After it's been filed,
Lordship,
we
we
have
may
to
be
follow
allowed to file a rejoinder to the affidavit,
Number
and
three,
Lordship, the interim
yes.
order.
Just after 1 week, the joiner will be filed in the meantime.
Lordship.
6 and 7 I have not been able to file because there are some defects in the affidavit.
Okay, then 2 weeks. Yes.
Lordship, the interim order may continue.
Interim order continue. It's a matter of 2 weeks to enable the petition to file rejoinder to the affidavit filed by the
Respondent
one by the state respondent, and for respondent number 7 to file for 4, 6, and 7 to file the affidavit.
Obliged.
Yes.
Obliged.
May it please your Lordship. Lordship, we were supposed to file the affidavit, Lordship, but there were certain defects which were identified at the time of filing. My Lord, I pray that we may be allowed just 1 week's time, Lordship.
What's the matter about?
This is non-payment of the bill, Lordship, not pension the contract. The completion report is there. It has been already 6 months, Lordship.
What's the amount?
Amount 47 lakh plus.
Okay, for 2 weeks' time, allowed to the state respondent file affidavit.
Much obliged, Lordship.
Much obliged, Lordship.
As per it for the 2 weeks' time allowed. Yes, MSK Gurungwe.
Lordship, the respondents are to file affidavit.
When was this filed?
But I'm praying some more time.
It's a fresh matter.
How much time? 2 weeks?
3 weeks.
As per it for the 3 weeks' time allowed.
Jen?
What instructions?
My lord, in this regard, my lord, some more cases have been filed, my lord.
Doesn't
One
matter, we are-
order
we are-
was there for
matter today.
for
If any
instance.
orders pass here, then that will.
No, my lord.
Surveillance worker?
Yes, my lord. Grateful worker, my lord.
Then?
Well, they,
You are? Serving as what?
Chowkidar, my lord.
Chowkidar?
Yes, my lord. There are 6 cases, my lord, 7 cases, my lord, here. Different posts we are holding. So the one we are, the first one is I'm holding as Chowkidar, my lord, for 10 years, my lord. 10, 12 years, my lord.
And what if the first case WPC number? 330.
330.
You're Chowkidar?
Yes, my lord.
Okay.
My lord, that advertisement has been floated.
Okay, 1 second.
No, my lord.
1 second. Okay. Yes.
Well, in the advertisement, I'm holding the post for last 12 years, my lord. An advertisement had been floated for.
It's for your post only. You sure about that?
So many are there, including Chowkidar's, in the same department.
But you want the stay of the advertisement. You feel that your post which you're occupying also been advertised?
Yes, my lord.
Then?
My Lord, there is some communications between the government and the district selection committee for consideration of the post, my Lord. My Lord, last time in WPC number 381, 82 and 84, last order was passed, my Lord, to take the instruction whether there can be similar nature. It is fixed today also.
No, my Lord, item 21, my Lord,
22,
is a case where item 21 arising out of the same advertisement, my Lord. Case was that your Lordship did not was not inclined to entertain the application. So their prayer was that whether they have missed the chance for filling the forms. So whether the last date for filling the forms can be extended or not. May I read that order, my Lord, of item 21? That it says, my Lord, in these writ petitions which are similar, the grievance of the writ petitioners who are otherwise qualified are of being overaged to apply for selection under the impugned advertisement, and as such have prayed for regularization of their services, and they have been serving for a considerable period. It has been pointed out by that there is no such age limit for the persons who are already serving the department for taking part in the selection process. Advertised wide advertisement dated 1st August 2024. However, submit that last date has since elapsed, and petitioner being unaware that there is no age limit, they may be permitted to put their application, my Lord. So the whole case is not for regularization.
Can be considered? They can put in
No, only issue in those matters are, my Lord, that advertisement was issued on 1st August. If your Lordship will see the advertisement, I will place the difficulty of the department before your Lordship, my Lord. That advertisement, if your Lordship will see, at page 44, my Lord, and that is of 1st August, my Lord. And today morning only I spoke to Deputy Commissioner also to know the status, my Lord. And the last date for submission was 31st August, my Lord. And the for some of the posts, my Lord, the examinations have already been conducted. And for remaining post, examination is likely to be conducted within a week or so, my Lord. It's too late in the day, and if we allow one candidate, then, my Lord, there will be entire sanction.
One-off thing, Your Lordship.
One-off thing meaning?
Your Lordship, just let them apply, Your Lordship, for the...
Very difficult, my Lord, that I understand,
Your
my Lord.
Considering that they've rendered services for a minimum of 15 years. Your Lordship, and one of the matters in writ petition, in item number 23, he had already been regularized, Your Lordship.
By whom?
By the officer who was not competent, my Lord, within one year, my Lord.
But Your Lordship,
within 1 year of service, my Lord.
Regularization is illegal or not, Your Lordship? The fact that he has been regularized.
That regulation.
There are letters also, my Lord, that the instances that previously also regularized in similar cases, my Lord.
And we relied on your Lordship's order previously, my Lord.
Similar cases have been, my Lord, in page
that order of detailed order considering all these aspects, my Lord, of the another district, my Lord, of similar advertisement, my Lord, of 10th June, my Lord.
10th June?
Yes, your Lordship. This is the detailed judgment which your Lordship has passed on this matter.
You got to give it last time.
Yeah, yes, my Lord. Paragraph 9, your Lordship has considered the appointment letter also. And, my Lord, advertisement provides for reservation, roster, everything, my Lord, because, and the process is also there. Those were without any, they have been working without any advertisement, without any process, my Lord. Now, Article 15, 16 of those who are not before your Lordship will also get violated.
Same advertisement in your case also?
Same advertisement.
Same advertisement. Those are the items.
Your Lordship.
21 to 24, my lord. Those are the items 21 to 24.
See, it was filling up by the District Selection Committee.
My lord, I would like to point out in page number 51, my lord, where it is for regularization, request for regularization, my lord, where it has been stated that already approval for regularization has been made in this earlier cases also. And page number 53, my lord, both 2 pages, my lord. Page 51, my lord, is written by District Health and Medical and Health Officer to the Deputy Commissioner.
But does not have to look with any right. Or he also Manju was for Manju was sweeper 10-12 age bar. Then how many posts are there, sweeper?
Your Lordship will see the advertisement, my lord, about
62 is
You mean to say the selection process already underway and is complete?
almost complete, my lord, and the examination in respect of some of the posts have already been conducted last Saturday, my lord, and examination will be. And my lord, they had ample time. Everything was there. They could have applied, my lord. Ultimately, your Lordship is aware that in advertisement and all, if we breach one date and we.
No, did we file the representation before the expiry of the advertisement?
No, my lord, they have filed now only.
After 31st August, you filed it?
Yes, my lord. They have filed.
My lord, there is one letter in page 53, my lord.
19 September, my lord. 19 September.
Petitions were filed after, Your Lordship, but that,
October, September.
but that was because, Your Lordship, these
Whatever the reason, but then whatever the reason.
My lord, kindly page number 53, my lord, where it has been written after the advertisement, my lord, to the Undersecretary by the Deputy Commissioner, Selection Commission.
Will have no bearing.
My lord, there is one paragraph, my lord, is considerable, my lord, in page 53, my
See,
lord.
the 2 bars is not appointed for 2007 to allow the consideration of regularization also by the cabinet. And number 2 is you all come after the expiry, the last date of advertisement.
My lord, since the petitioners are, my lord, working for more than 14, 15 to 12 years, my lord. My lord, my humble submission that if the department conducts any special interviews, special examination for them only.
It comes only when if
for them only, my lord.
Now,
for those who are working for more than 12 years, 10 years, my lord, if a special examination is conducted, my lord, for consideration.
Have you applied or not?
That is also not clear. No, there is nothing. There is nothing in the writ petition, my lord, saying that they did not apply.
He didn't apply.
we could not apply.
We could
My
not
lord,
apply.
there is nothing in the writ, not a single line also.
Why did he come so late?
Your Lordship, we were not.
The moment the advertisement had come out on, advertisement come had
1st August, my lord.
1st
1st
August.
August.
advertisement issued on 1st August.
1st
August.
And last it was 31st August.
31st August.
That was very short also.
1 month, my lord. 1 month.
Very strange because usually government, by the time those
What has
elections-
happened, my lord, is that now in each district, your lordship has seen that now each district selection committee has been constituted, my lord. Where they now 1 month, and they are all in service because it is there, they are working there only, my lord. It's not that they didn't have the notice.
But the appointment was subject to selection by the district selection committee, correct?
Yes, Your Lordship.
Then you can't because
Temporary
everything-
post and undertaking is also given, my lord. Undertaking.
Everything flows from your appointment order.
Because now we are trying to streamline.
We can't twist it and say.
Sometimes we have hard cases, my lord, but.
No, hard case in the sense that, see, they are ready to participate.
Yeah, probably, my lord,
But-
if I will find out if, because I don't know, because not a single line is there that they have
No,
not
no,
applied.
if we can just see some, only for these petitioners, without setting a precedent.
Yeah, your
if they
lordship,
can
because
put in- if
that
they can
if
be-
we do not have that, if we cannot, if we modify, my lord, if the orders come from your lordship, some
No, orders will flow if the selection process can still accommodate them. That's what it is.
That your lordship may pass that order and dispose of the writ petition in that if that is the possibility.
But
Is there.
that leaves them neither here nor there.
Because that in
That
any
gives
case,
you
my
that-
lord,
see, the
in
thing is
any
that,
case they have.
yeah, any orders passed should be a bit definitive. You know?
Yeah, the
They'll
only
know
issue
whether,
is-
they'll know whether they'll be able to
No,
take part.
only issue, one via media which can be found, my lord, is that now we are virtually at the fag end of the entire recruitment process, my lord. Issue is that the candidate or petitioner cannot come and say that I was not aware of the advertisement and I did not know and therefore I did not apply, my lord. That if that is that is accepted, we will have a lot of difficulties in running the administration, my lord. Now, if they are saying that they did not apply or they could not apply, they should make a representation which should be, because we do not have power, my lord. Because if I tinker with my own advertisement, my lord, then others will also say that I could not
So
apply.
if they come before this court,
So then also,
when advertisement was still
then we could have
alive,
possibly
then in
extended
their
the
case-
time, extended the
yes,
time.
In
also.
their case, that means you have come before the
And your lordship has-
lapse. Then maybe court can there. You look, there's some decisions also.
Yes, my lord. That's and your lordship has seen in that teachers scam matter when that date was accepted, form was accepted after cut-off date. They are all facing cases because of that only. Those are bona fide decision only I have seen, but still, I don't have power, my lord, to do that.
There's a problem that we thrown out of employment now. It's not in the selection process.
Yes, ma'am.
If they've been working there, then with the approved selection also, there'll be
They are
the fact that they serve will be given due consideration by the district selection committee also.
Yes, my lord.
But then if not put them on selection by their own ignorance and feeling secure that the
First, my
team
lord,
is
let them file the affidavit because let them file the affidavit that did not apply, my lord, because they are saying because the instruction
you file.
instruction
Then you have to
My lord,
none of you applied. None of you applied.
that
My lord,
or you submit the application with the affidavit that I did not apply, I applied. So then there will be some material. We are court of record, being so High Court being court of record, we have to have some material.
That we can pursue with this. That is a good size. My lord, it's my submission, my lord. It's not. Earlier also, my lord, government cabinet has already approved those who were.
Those were in terms of Uma Devi, my lord, before 2007. My lord,
before 2007, my lord.
Lordship
Those who are working for a long time.
That was the mandate of the Supreme Court
They
only.
approved
That was
2007
because that
decision
cut-off
was-
decision is
it
there.
had a certain number of conditions also.
Yes,
One was
yes.
that the appointment of that so-and-so person should be a sanctioned post.
Yes.
Then that they will put themselves up for special selection.
Yes.
That's why they had a special selection for people to see what they fit or not.
So,
So
my
that
lord,
those conditions have to be met. Now, in your case, is a question of just asking for authorization straight, and you have not come when the advertisement was, to say that the advertisement has been floated, like we are working there. At that point of time, then you could have participated. Now, after advertisement had been floated, after last year had gone, then you come to the court.
it's my humble submission.
So you're sleeping all along that time.
My lord,
Your appointment order says that subject to a regular selection by the district selection committee, the appointment is temporary. That's very clear in black and white. So the petitioners can't claim that, we are not aware of a terms of appointment. We thought that we're going to regularize when it clearly says that has to be regular selection procedure.
but my lord, we have.
We see the
for-
thing is that it's very difficult.
That
Some
is-
cases very difficult. We understand.
Yes, my lord.
In arguing the case also, but the facts are facts. And having sympathy, then all cases, if they go in sympathy and compassion, then the law then must well throw it outside the window.
But my lord, these cases, they will be helpless and they will not be able to do anything.
Case of sympathy, every petitioner will come. I'm old. I'm broke. I'm cold. I'm hungry. Then that on that relief. You find affidavits saying you have not applied in all these cases. Even in your case also.
Yes.
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 Similar measure.
First in this item number 10 to
16.
10 to 16.
In these matters which are taken together, though the writ petitioners have been stated to be working temporarily for a number of years. With the appointment being subject to regular selection, comma, in terms of the comma, it is submitted that they have not applied when the advertisement, impeding advertisement dated
1st August.
1st August was floated stuff. On these submissions, then after general, on these submissions, then after on these submissions, then after general. Only submissions are that has replied by where's up an order? By this statement, what statement? Implies ad hoc basis because their names were sent also.
And if your lordship will see the advertisement also, my lord.
By submitting that it is not possible presently to allow the petitioners to put in the applications in as much as the selection process is already underway. However, he submits that the petitioners can be allowed to file an affidavit showing that they have not applied in terms of advertisement for further consideration of stuff. Accordingly, for further consideration of this court, the petitioners in these situations are directed to file an affidavit declaring that they have not applied for the posts in question as under the impugn advertisement. When will you file it? Just after 2 weeks.
Because the first time, my lord, advertisement was issued on 29 July 2024 also. And thereafter there was some corrigendum was issued. Corrigendum is of 1st August, my lord. So therefore they had the ample time, but still they can.
Yes. Other matters, your item number 21 to
24,
same order.
Published.
What? How long have you? Is one batch was differently, the other batch was differently. Very difficult, Mr. Adnan.
Well, we have to find out some. We have to give them some relief, my lord.
But in one case, my
For
lord,
the long time of service.
the wrong precedent.
No, the only thing is that if they can, if second process is going on, then since by work there'll be a special case because they've been working for long, then maybe some consideration be given.
Yes,
That will
Lord.
be the discretion of the court.
Yeah, that is the discretion of the court.
17.
Yes.
Lordship, we pray for some more time, Your Lordship, to file an affidavit. We are still awaiting instructions. This is regarding salary of the High Court
What, number
employees.
5? You're opening number 5?
No, he is with me, Your Lordship. The Registrar General, I think. Yes. Yeah.
Number 5, you can't serve here also.
We can, if the court allows, we can serve by custody.
What was the last order?
Oh, no service complete, yes. No, not appearance on number 5. Often indicates that service upon number 5 is complete, but there's no appearance behalf that is upon today. Like for MST Yangi, then AG pays for the further 2 weeks time. Well, affidavit. There's that afterwards.
18.
Affidavit filed.
Not yet filed. I'm trying for some more time.
Why? You are M. Thakuri.
Yes, Lordship.
Give him some more time. No.
No objection.
Yes. As prayed for the 2 weeks time granted by affidavit. Yes. This thereafter also. Yes.
Oblige you.
19.
May I please, Your Lordship? Lordship, in this matter, as per the instruction, Your Lordship, the election is already being held on 13th of this month. So the matter get infructuous, Your Lordship. Please allow me to withdraw the matter.
Yes, Mrs. M.S. M. Rahman submits that as elections have since been held, the writ petition has been rendered infructuous. So she prays that the matter will be closed as infructuous. According matters closed disposal as infructuous.
I'll oblige Your Lordship.
Oblige, Your Lordship.
20.
Here also I'm paying some time.
Where's the petitioner?
Kishore Gautam, Chamber.
Is the school death matter?
No, my lord. This is sexual harassment complaint, my lord.
How long? None appears for the petitioner?
3 weeks time, my lord.
List after?
3 weeks.
3 weeks, yes.
25.
You served number 3 and 4?
Yes, yes.
You served?
Lordship,
Where's the office noting?
I
Not
have
received.
taken a step, Your Lordship, but I have already taken step, but I don't know. Well, Your Lordship,
Yes, anything to say? Word file affidavit?
Lordship, I think so he wants to say that he wants to close the case or something.
Yes.
Your Lordship, it seems like they have come to the settlement, Your Lordship, with
Who has come to settlement?
by
Is that
this.
correct?
They have intimated me, Your Lordship, just, but not in writing.
Okay. Stop and communication dated 5/11/2024 has been produced by the writ petitioner showing that the matter has since been resolved and the prohibitory order been revoked. Stop. Next paragraph, accordingly, as nothing is there for consideration, the matter is closed and disposed of. Disposed and closed off. Disposed and closed, yes. Copy of communication dated 5/11/24 is taken on board with part of the record, yes.
All right.
The record of presence also, yes.
26.
May I please, Your Lordship?
I please, Your Lordship. As per the
Yes, 10
last 10 days, Your Lordship, I have taken step, but out of I have taken step on 7th, but 6 days holidays, Your Lordship. So Your
Where
Lordship,
6 days holidays?
8, 9, 10, 15, 16, 17. So out of these 6 days are holidays, Your
8, 9, 10, 3 days. 16,
15, 16, 17
11,
holidays.
12, 13, 14 working days.
But Your Lordship, I have taken step from.
So the officer took holidays on
No,
from 8 till
I am
17?
submitting, Your Lordship, because on 7th itself I have taken step, Your Lordship.
By telephone or by
No
letter?
telephone, no, by letter. Here, no, it is reached to the directorate on the same day, Your Lordship. Your Lordship, 2 weeks time may be given, Your Lordship, because petitioner is near parents, Your Lordship, and notice is also not issued to the principal also, Your Lordship, last date.
My only humble prayer, my lord, is to the respondent authorities has twice attempted to conduct parent and guardian meeting to constitute the managing committee of Hydebury High Secondary School, but before one day the meeting was postponed, my lord. So my only humble prayer
The only instruction
in
you why
similar
postponed twice.
Yes, my lord.
Yes, your lordship. That's why your lordship. I have. This is the proof, your lordship. I have.
I'm not
written-
talking about your proof. You telephone him right now.
Yes,
Who's the person concerned? You don't have the
District
personal
school.
contact
Yes,
with the then?
yes, your lordship. I have the phone number.
Then?
Directorate is here in Shillong and SDSU in
Now
Tura.
in the age of, you don't need to even to send a physical copy. Now even for leave applications of judicial officers, you just get emails.
Yes, your lordship.
Then?
But your lordship.
He's saying Bagmara and not so, they want to casual leave for tomorrow.
Yes.
There'll be a letter to come Bagmara. Then after 2 months,
Your
have
lordship,
passed, then
I'm-
I get letter and I sanction the leave.
Digitalize everything, lordship, now.
It doesn't work that way. That is a proof 7th you send.
But your lordship, I am with.
How does it go? When you send it, how does it go? By
No,
special-
this is the process, sir. But it is on the same date. It is.
No.
Oh.
Who delivers the letters when you seek instructions?
That is from they come and collect it.
See, the thing, instruction doesn't mean affidavit. Instructions mean you telephonic instructions also. You've been government advocate for how long?
30 years, 31 years.
Then?
It's 31 years.
31 years, your lordship. But it is not that, your lordship. I am just avoiding cases.
Yes. It looks like that.
No, not your lordship. So many my cases are over by 3 months almost.
Yes.
My lord, in that case,
this
my
is
lord.
a matter on Monday.
My lord,
Instruction
humble,
received by then, yes.
my lord, my humble prayer, my lord.
Monday, yes.
Only in the meantime, the respondent shall not, my lord, issue any interim committee or
But
a
he is
special
the
committee.
parents of the guardian of
So
a
what?
student,
That-
your
if
lordship.
that order goes, will
So
not
without
affect
government
anybody, my
authority,
lord.
how stay can be granted?
Monday.
My lord. Deeply obliged.
Wait, please, Lordship. Lordship, in terms of the last order, we have taken steps on respondent number 6 and 7, Lordship. Service is still awaited, Lordship.
One, 6 and 7.
Lordship, 6 and 7.
Yes, office note indicates that the service on 6 and 7 is not yet complete. Stop. Yes.
Lord, we received some telephonic instructions for that. My lord, the order which they are challenging, my lord, that was issued under bona fide mistake, my lord. Nevertheless, my lord, the pursuant to the direction of this honorable court, the director, school education, has already written to the department, my lord, to maintain the status quo as directed by this honorable court. So, my lord, as far and
That
in terms
status-
of parawise comments, my lord, we require some time to
Yes,
file.
take down Rescuer Jaji of 1 to 5 days without further 2 weeks time to file affidavits of this is matter after 2 weeks for affidavit and for appearance and for service report on this 1, 6 and 7. Stop petitioners permitted to obtain status of service in the meanwhile. And last interim order passed shall continue next date.
My lord, this is related to that appeal also, my lord, the Tilapara appeal, which is pending before the division bench of this honorable court.
Which is not admitted, Lordship, at this stage. It is at this.
Filed by you.
No, my lord, it's filed by the managing committee.
Hearing, item 34.
Obliged.
May I please, Lordship?
Yes.
My Lord, petitioner hearing discharge from service on medical ground, my Lord. She was appointed as a rifleman GD female on 31st/3/2015, my Lord. And during the battle physical efficiency test, that is BPT, she fell down. And she reported to the medical, my Lord, that is annexure 4, page 21.
Yes.
She reported to the medical, my Lord, and typed copy is that page
Annexure?
22, my Lord. Annexure 4, my Lord. Annexure 4, my Lord.
Page?
Yeah, page 22, my Lord.
Yes.
This 25 years old recruit of Assam Rifle Training Center and School reported to ARTC care of pain in the left hip joint following BPET. The pain is persistent 1 month, my Lord. Thereafter, she was referred for the specialist opinion, my Lord. That document has not been annexed in the writ petition, but in affidavit in opposition, it is there, my Lord. And thereafter, my lord, she was discharged from service. That is Annexure 7, page 26, my lord. The petitioner was discharged from service on medical ground, my lord, on 30 September 2016.
Yes. On?
My lord, 30 September 2016, my lord.
24th September?
Yes, my lord. Order dated 24 September 2016 and discharge date is 30 September 2016.
You see, what do you write in your synopsis then?
Synopsis, my lord, there is a typical mistake. There is a discharge date has been written wrongly, my lord.
Enrollment
That is the date of discharge. Yes, my lord, that is date of discharge, my lord. Actually, the date is 31st 3 2015 enrollment date, my lord.
31st 3 15.
2015 is date of enrollment, my lord.
Yes.
And 39 2016, that is the date of discharge on medical ground, my lord.
Yes.
Thereafter, my lord, petitioner approached before the Manipur High Court with a prayer for reinstatement into service, which was disposed of by the Honorable High Court Manipur, with the direction to dispose of the appeal of the petitioner. That appeal has been disposed of and rejected, my lord. And thereafter, we have filed a legal notice to the department with the prayer to grant the invalid pension, my lord.
But she served only 1 year.
1 year.
So 1 year.
1 year, 1 year, 6 months and 1 day, my lord. That legal notice with the prayer of invalid pension has been served to the department, my lord, on 30 October 2021. That is Annexure 13, page 41, my lord. That prayer has been rejected, my lord, on that is the next as page 44 of Annexure 14, my lord.
Then 21 to 24 we doing? Or 22 we file this case, okay.
Yes, my lord, we have filed the 22, my lord.
Yes.
That letter has been submitted to that petitioner on scrutiny of the citol of your client so and so. It is revealed that she was enrolled in Assam Rifle on
Now
so and so and discharged.
1 second, Mr. Kumar. Now this para 3 of this reply, it says that, yes, read that.
It is intimated that in terms of para 3A of CCS Service Extraordinary Pension Rule 1939, the disablement should be attributable to or aggravated by service condition with 1% disability and above disability for grant of disability pension. As per medical board proceedings, the disability of your client was neither attributable to nor aggravated by service condition with nil percentage of disablement. Hence, she is not entitled for grant of disability pension, my lord.
And how do you say she is entitled now?
My lord, kindly come to page number 15 of affidavit in opposition. That is Annexure 2, my lord. This is the opinion of the specialist, my lord, and typed copy as page number 16. This 25 years old female recruit, a case of old healed patches disease with coxa magna left hip, become symptomatic with pain left hip following a fall up during BPET, my lord. That is the part of training.
What's BPET?
On BPT, Battle Physical Efficiency Test.
Okay.
On 1st September 2015 at Dimapur. And the specialist opinion has been, that is the last line, my lord, recommended to be invalidated out of recruitment training as low medical category A5, my lord.
Okay.
Last line. Thereafter, my lord, kindly come to the opinion of the medical board.
Yes.
There, page number 19, my lord, of their affidavit in opposition.
Yes.
Actually, the respondent authority denying my prayer that we have a childhood disease, my lord. But that opinion is clearly stated, that is number 1, my lord, does the disability exist before entering service? No, my lord. They have recorded my, that is page number 20, my lord, they have recorded my disability as nil. Page number 20, bottom, my lord. Percentage of disablement, nil.
Yes.
And page number 21, my lord, recommended to be invalidated out of service in low medical
percentage of disablement? Nil.
Nil.
At 4.
Yes, my lord.
Page
At
20.
4, my lord. Yes, my lord. Page 20 at 4.
Yes.
And now page number 21 says in paragraph number 7, my lord, medical category awarded to me, recommended to be invalidated out of service in low medical category.
Yes.
A5.
R5 or A5? A5.
My lord. So my prayer before your lordship in similar, I am only placing 2 judgments that I have annexed in my affidavit in reply, my lord. Kindly come to the page number 15, my lord, of affidavit in reply.
Yes.
That is a similar judgment, my lord. And page number 17 is the relevant portion, grant of invalid pension.
Yes.
That is the letter of the letter quoted of, this is the letter is the from respondent authority. Invalidated out paragraph 2, my lord. May I read, my lord?
Yes.
Your case for grant of invalid pension was taken up with the headquarter DGR Shillong wide above letter number so and so in terms of rule 49 2B of CCS pension rule 1972. Minimum 10 years qualifying service is mandatory for grant of invalid pension, and disablement should also be attributable to service condition where the said disease, that is such and such disease, is neither attributable nor you have completed 10 years of qualifying service, my lord.
Yes.
Now, my lord, come to the page paragraph
10 years
number
not required.
7.
The other case we don't talk about Musika. 10 years is for regular pension.
10 years
for disability.
Yes.
And now come to page number 18, paragraph 7, my lord. The Honorable Division Bench of Guwahati High Court has clearly stated. May I read, my lord?
Yes.
We also fail to understand as to how the injury, that so and so injury, fracture this was a pre-existing disease, and even it was a pre-existing disease. How was the petitioners to know about such a disease, and whether the petitioner has deliberately withheld this information from the authority is also purely in this realm of conjecture. Although one of the grounds of denying the disability pension to the petitioner was that he was supposed to disclose the disease, as he had not done so. Moreover, before recruitment of the petitioner as rifleman in the Assam Rifle, he was put to a rigorous medical examination, and only after qualifying this rigorous medical examination and other requisite tests, he was appointed as a rifleman. Now it is not given to the authority to say that he had a pre-existing disease. So my rejection, they says that this disease is a pre-existing disease, my lord. How they can say, my lord, and my medical opinion as well as my medical board, it itself says that during the fall of BPET, the petitioner was injured.
Yes, Dr. Majika. If the medical board says that there was no injury prior to the enrollment, and the injury was sustained during training, and how can you deny the petitioner?
The only thing is that, my lord, that report says, my lord, in my affidavit. Let's refer to that. Page 15 of my affidavit, my lord. The 25-year-old female recruit, a case of old healed pulse disease. So the disease was existing, my lord, pre-existing disease.
But medical board says otherwise.
But medical board deals with disability, my lord, not disease.
This is different.
My lord.
Even in the other case, the person had some defects, whatever. Then you selected this candidate, correct? You selected her through a regular selection process where her physical abilities were tested, correct? Now she was enrolled, she served over a year, and then after this BPET whatever fall, on 1st September at Dimapur, then she developed this pain, right? Then you find that the Sesqueta of old Perth's disease with coxa magna, lateral whatever, and so and so. That is why she won't be able to withstand regular combat duties. That's why she was of the given opinion that she be invalid out of service. So then, and the page 15, your page 15 says.
It says, my lord, this 25-year-old female recruit, a case of old and healed.
Old and healed.
Was a disease with coxa magna so and so, became symptomatic with the pain hip following a fall.
Yes.
During so and so.
Then why is the Open Medical Board at page 19, which you annex, does the disabilities exist before entering service? No.
Well, it appears the word used is disability, my lord. Does the disabilities exist before entering service? No.
Yes.
Now then it says, my lord, in respect of each disability, the medical board on the evidence before it will express its view as to whether it is attributable to service during peace or under field service condition. No. It has been aggravated during or remains so. No. Connected with service. No.
So who's the author of this medical board report? You just put no everywhere. You didn't examine the soldier also, it means. Because it makes no sense. Does it exist for entering service? No. And attribute to service? No. What does it mean? Aggravate thereby? No. Connected to service? No. And it says that there's no disability before entering service. Then how did she get it?
So like compare the instructions.
In respect of each disability shown as attributable under A, that's under A, the board should state fully a specific condition, pain, and service which cause disability. Not applicable. Mean who wrote this medical report?
Well, I'll come back with
and this is very important. See this next one, this C1. The specific condition and period in service which aggravated disability. If he says disability before under service, and he writes NA.
But what I understand, my lord, these are very hidden kind of disease, my lord. Normally, whatever blood test and all those regular examination is done, but these diseases cannot be discovered by those tests, my lord.
See, and look at this next page. Attributability, so no. That report was aggravated negligence, no. Hasn't she refused uncooperation, no. Has the effect of refusal been not applicable? Care, disability. So, 4C, what is the present degree of disablement as compared to a healthy person, but it be expressed as nil. Nil. Then is individual in need of further treatment. What nature? And they write lifelong treatment. So they have no disability in what treatment? And medical category awarded, recommended to be invalidated out of service. So it means this is very perfunctory.
What it appears, my lord, that this disease.
Childhood disease.
This is childhood disease, my lord.
Yes.
And in regular examination, recruitment examination, this disease cannot be discovered, my lord. Because the other case of Guwahati High Court cited, there is a clear finding in that, my lord, that he suffered injuries during the training.
No, he had some other. He fractured his foot, but as he read just now.
So that was a very clear case of injury. So that cannot be said that it was not in the constitution.
Came because after she fell, but during recruitment, then let him take instructions, Mr. Kumar.
My lord.
In the course of in the course of the hearing, when the medical board proceedings had been placed by the counsel for the petitioner, wherein it has been indicated, wherein it is stated that the disability did not exist before entering service, whereas it is maintained by the respondents as a pre-existing condition, and notwithstanding the absence of condition, that Dr. M. Ozika is allowed to obtain some further instructions, as it seems to be contradiction in the medical board itself. This after
2 weeks.
This over 2 weeks.
My lord.
36.
Much obliged, Lordship.
My lord, the respondents wanted to raise objection to the wants to challenge the maintainability of this writ petition, my lord. So, my lord, if they can,
senior will start.
Yeah, if they can advance.
No, the only thing, my lord, if your lordship will see the prayer in the writ petition. Now, to issue a writ of certiorari setting aside and quashing the impugned result of the interview. Now, what has been impugned in this writ petition, my lord, is result of the interview dated 29/11/2023.
This page?
Page 22, my lord. Yeah.
No, of the result interview. Not the prayer.
Yes, I'll. 55.
Yes.
Now, this is merely the result for the interview of the post of so-and-so, conducted by the Commission on 21st November 2023 is hereby declared. The names of the successful candidates recommended by the Commission are as follows in order of merits. So this is recommendation. Recommendation of candidates shall not confer to claim, but they have not challenged the appointment letter.
You've not done that?
No.
Then? Like this
Now, what relief can this court?
Like this stand on its own footing.
My lord.
I mean, there's no relief you'll get
Yes,
for a challenge like
no,
this.
no relief can be passed by this court. Because that is merely a recommendation.
Consequence upon these recommendations, my lord, the
No, but if the opponents are under challenge, then?
My lord, my rejoinder affidavit, my lord, to see.
We won't take the rejoinder, and Mr. Yobani, you have to keep making appointed challenge. Where's the appointment?
Appointment we have annexed in the.
You have annexed it in your writ petition itself.
No.
No, my lord, at that point of time, we do not have the copy of the appointment order, my lord. Because, my lord, basically what is the issue here, my lord? The issue here is, my lord, a person, my lord, who submits a fake certificates, my lord. A forged certificates, my lord.
Who some fake certificate?
My lord, the private respondents, my lord, who have
They are
been
presented by
selected, my
whom?
lord.
Purportedly by me,
senior,
no?
senior
My lord,
counsel.
I'll show, my lord.
Yes.
Because there was a...
for the state.
Your Lordship, on the basis...
Mr. Deb appearing for whom?
Respondent number 5, private respondent.
That was like the candidate.
So, my lord, now the appointment order comes as a consequence
When
of
did you file the petition?
the writ petition was filed in
1923.
23, my lord.
23, right?
Yes, my lord.
Okay, and when was the appointment order made? This select list is 29 November.
Yes, my lord.
Okay, 23.
It's at page 50 of my affidavit, my lord. The
When
appointment.
was the appointment made?
Appointment is 20th December 2023.
Oh.
Page 50 and extra 5.
Oh, that's why.
So this is a this is subsequent to my this thing, my lord, my writ petition, my lord. So, my lord, the issue here is, my lord, a person who submits a false certificate, a forged certificate, and on the
but
basis.
it was not detected by the MPSC.
I'm sorry, my lord.
It was not detected by MPSC. Also.
MPSC have called the concerned officer who has issued the certificate, my lord.
What certificate is this?
It's an experience certificate, my lord. And the officer who has issued the experience certificate very clearly mentioned before the MPSC that this is not a certificate issued by me. Now, consequent
Why is that? Is that very vital for the selection?
It is very vital, my lord. Because, my lord, even if we say that, okay, for a moment, my lord, even if you say that experience certificate is not vital, just assuming a person who already submitted a forged certificate
Should
in
be
order
out
to...
of contention.
Yes, my lord. So therefore, my lord, now what did MPSC did? When the officer says, the concerned officer says that this is not a certificate issued by me, then the candidate goes on to file an FIR against the officer who comes and says that it is, who comes and states the truth, my lord. Now, so this is besides the point now. So, my lord, the issue is here, my lord, whether when a person who submits a forged certificate and secures a job, my lord, can such a person have any leniency, my lord? Or such a person has a right
Shown
to...
any leniency.
Yes, my lord.
Yes.
So, no, my lord, I'll just take very brief facts of this case, my lord. There was an advertisement issued by the Meghalaya Public Service Commissions, my lord, that is on 14th November 2019, my lord. The advertisement will be at page 26, my lord, of my writ petition. Page 26 of the writ petition, my lord. And the relevant is at page 29, my lord. Page 29, serial number 13. My lord has.
Yes.
So may I just read, my lord? State organizers, scouts and guides. State level, so this is, we'll skip for a moment. The experience, my lord.
Where is that?
Page 29, serial number 13, my lord.
Serial number?
13, 13.
In page 39?
Page 29, 29.
Oh, sorry.
29 of my writ petition, my lord.
Yes.
So, my lord, here this is a post for filling up of, for filling 2 posts of state organizer, my lord.
Yeah.
Scouts and guides. So the experience, my lord, in the experience portion, if my lord will see, serve as an assistant organizer for more than 3 years in the state or in other state Bharat Scouts and Guides. Number 2, must have complete graduation in scouting/guiding of any section, HWB holder.
What's HWB?
HWB is a Himalayan wood badge holder. It's a course, my lord. They call it a Himalaya wood badge, my lord. And my lord, must have attended national events, conducted leaderships, training in the states and districts, additional qualification, my lord, computer knowledge, and so on so forth, my lord. Now, my lord, consequence upon this in response to this advertisement, my lord, 29 candidates applied, my lord. 29 candidates applied. All the candidates got rejected for lack of experience, my lord, including the respondents who have been selected, my lord, now. And I also, my lord. All of us, we got 29.
1 second. More than 3 years.
Yes, 29 candidates applied.
3 years experience required.
Yes, my lord.
Yes.
So all of us, we got rejected in the first round. And on 24th November 2019, my lord, there was a notice for representation. So I also filed my representation, like others, even the private respondents.
So after the rejection of all the applications,
yes,
do you allow to represent against them?
Yes, yes, against the. So I was rejected there, saying that I do not have the experience certificate as required, my lord. Now, then the select list came, qualified list came, the respondent, private respondents, my lord. Now the private respondent, my lord, I have been appointed, my lord, in the Bharat Scouts and Guide as an assistant state organizer, my lord. And there's a proper recruitment. I have been appointed. I am the permanent member, and I have been serving for them for more than a decade, my lord. And I know very well, my lord, which officers is there, which officer is not there.
So you work for 10 years. You have 10 years experience, you mean?
My lord, as an SOC, my lord, subject to corrections, my lord, SOC, I was appointed as an SOC, my lord.
What's SOC?
Assistant State Organizer, my lord.
ASC or what?
Assistant State Organizer, ASO, we call it ASO, my lord. So I know very well, my lord, who is working as honorary, who is employed, because.
1 second, sir. Yes.
So, my lord, now, my lord, I was surprised to see the private respondents, my lord, their names in the qualified list, my lord. So that is the reason why I filed an RTI before the commissioner, my lord. It is not, I am not aggrieved because I have been disqualified or I have been rejected. It's not a point. But the point is that, my lord, somebody whom I know that's not entitled to, is not experienced, or is not even a member of the organizations, is found to be in the select list. Therefore, I file an RTI. When I file an RTI, my lord, I was surprised to see that the respondents have submitted an experience certificate stating that they have been serving since 2016, my lord. Now, my lord, page 40, my lord, of my affidavit, or of my petition, my lord, page 40. This is what I've come to learn, my lord.
9 March 2021.
Yes, my lord, 9th March 2021, my lord. It says certificate and authentication certificate. This is to authenticate the two following works of Miss So-and-so that has been conducted and learned leadership camps in Meghalaya, notably led by contingent of guides to Philippines and in Asia Pacific, Jamboree 2009, as well as serve as international service team in any area of activities with huge exposure to international and national communities as required in our organization, the Bharat Scouts and Guides. Although not fully employed, Ms. So-and-so has been serving as honorary, non-salaried assistant state organizer and a member of the state executive and a state council of the Meghalaya Bharat Scouts since 2016, my lord. Since 2006. Now, my lord, I'll just stop here for a moment. If this application, if this certificate is to be true 2016, then the respondent number 5 comes within the experience. She is qualified to apply, but this is not the case, my lord. Now, my lord, I have confronted the state secretary, my lord, who has issued this certificate. And I said that you know very well, by writing a letter, my lord, you know very well this lady has never served since 2016. How did you issue this certificate? She replied to me saying that, no, I've never given her that certificate. My lord, that letter, my lord, will find at page 42, my lord, annexure 9, my lord. Well, may I just read this one, my lord? This address is to me, my lord, Dashimti Kharkungor, by Srimati Eswia, retired State Secretary. Dear Dashimti, said, I am deeply shocked and saddened to hear the RTI inspection report from you, and also express my willingness to clarify the following facts and figures as per my record during my period as a State Secretary, Meghalaya Bharat Scouts and Guides, State Headquarters, Shillong. I would like to clarify to you that as per the original experience certificate issued and duly signed from my end, it does not match with the RTI inspection report mentioned by you in your letter, which on the other hand had confused me a lot. I remember carefully that the original experience certificate issued to Srimati so-and-so, duly signed by me as per my record, she was given a certificate as Honorary Assistant State Organizer in the year 2018, not 2016. As mentioned by you in your RTI inspection report, the certificate was issued only on her request with good intention to help her in promoting scouting and guiding, but unaware and deeply shocked that so-and-so had misused the experience certificate by tampering or forging all the original information duly signed from my end. Without any consultation, if the matter was true as per your RTI inspection report, a record copy of the experience so-and-so. Moreover, the experience certificate issued from my end cannot be treated as an appointment order, as there is no official appointment order issued to her, and she has not appointed as an Assistant State Organizer in the office of the Meghalaya Bharat Scouts and Guides. She is not an official staff nor working in the Meghalaya Bharat Scouts and Guides, but a voluntary leader trained as a Scout Master as per my record till the date of my retirement. She has just only a volunteer of association, so has to organize form units. During my period as a State Secretary, there was no staffs working in the Meghalaya Bharat Scouts and Guides without the appointment order issued to them. In my capacity, so-and-so, my lord. So now she clarifies by saying that, no, this is not the certificate that I have issued to her. Now, my lord, so with this, my lord, I would like to point out few documents, my lord, which will prove the certificate is fake, my lord. Number one, my lord may kindly come to page 40. Page 40 again, my lord. Page 40, my lord, where she says that this is certificate 2016. And page 42, my lord.
Oh, is it 2018 or 21?
No, 2016.
No, page 40 is 21.
Page 40. I'm sorry, my lord. Read petition, page 40, annexure 7.
Yes, this certificate, authenticate certificate.
2016, the last word, the last.
Where is that? Oh, since yes, okay.
Yes, my lord. So, against this certificate, my lord, the first thing is that, as I've just pointed out at page 42, the retired secretary has said that this is not a certificate issued by her. This is one point, my lord.
Yes.
Now, the second point is, my lord, I have filed a rejoinder affidavit, my lord. Can you have my rejoinder affidavit, my lord, that was filed on 11th July, my lord? My lord has got a rejoinder. Rejoinder filed by
yes.
So, my lord, may kindly come to page number 9 and page number 10, my lord. Page number 9 and page number 10. We have wrote an RTI, my lord. Wrote an RTI to the Bharat Scouts and Guides, my lord, requesting for information who were the permanent members in the year 2015-2016 and who are the honorary members, my lord. We have sought for a list, my lord. And this is the list at page 9, my lord. It's a list of, my lord has got page 9. It says a list of employees and honorary of the Meghalaya Bharat Scouts and Guides, Shillong for the year 2015-2016. Can you look at this, my lord, as where and no up to 24 honorary members were there. None of her name is not mentioned here, my lord. And page number 10, my lord, we'll see, page number 10, we'll see the employees, the list of the employees of Bharat Scouts and Guides, my lord. Here also 1 to 20 employees are there. Her name is not there, my lord. So, my lord, when her name is not in the roll, either in honorary or as an employee, how can she get a certificate saying that she is working since 2016? This is the second point, my lord. And now the third point is, my lord, kindly see at page 33.
Of rejoinder?
Yes, my lord, of the same page 23, my lord. My lord, this is the official noting. This official noting is after the respondents, the private respondents got appointment order and they have joined the service, my lord. This is the official noting of the state secretary, the present state, then the secretary, my lord. It says that my lord has got a type copy 33 below, my lord. The last 3 lines from below, my lord, SOG. As state organizer guides, it is mandatory to complete the basic course for guide captain. Therefore, you are to join the said course to be held in our Shillong headquarters from 23rd, 29 April. Now, this is also very important, my lord. My lord will see the Meghalaya Bharat Scouts Guides rules. Where is that? Which one is it? Where? Where's the guide rules?
Where's the Meghalaya Scouts and Guides rules?
Yes, my lord. Page number, my lord, kindly comes directly to page number 9, my lord. Page number 20, sorry, of the rejoinder itself, my lord. I just wanted to point out the rules, my lord. F, my lord, has got page 20, the point number F. F.
Yes.
Yes, my lord. Now it says Assistant State Organizing Commissioner, Scouts and Guides. The person appointed to this post must be a graduate from any stream with knowledge of computer at MS Office level and work as computer operator. The second point is very important. Be trained Scout Master, Guide Captain who has completed advanced course. I will stop here, my lord. Advanced course. Now the State Secretary writes to the SOC, saying that you didn't even complete your basic course. Now the SO is in hierarchy bigger than the ASO assistant. So even for the post of assistant, you need to finish your advanced course.
We'll continue at 2:15.
I'm sorry?
We'll continue at 2:15.
Oh, yes, my lord, 2:15, my lord.
MPSC having difficulty in answering?
MPSC actually that Mr. Paul had mentioned in the morning is not...
He'll be here tomorrow.
We can continue day after, otherwise, because tomorrow...
Day after, yes.
Yes, day after, my lord. We'll continue.
Bring authorities also.
Yes, my lord. Authorities I have, my lord.
Yes. This is for here giving after tomorrow.
My lord. Obliged.
They've already joined.
Yes.
They have joined. They have joined.
Well, in this case, there's also an FIR which is filed by me, and as per the charge sheet, this certificate, everything was signed by that secretary. And in fact, that lady has also filed a 482 application before this court, which has since been dismissed.
No,
So there appears to be a collusion between the...
Collusion will show, my lord, who has a collusion.
Collusion lead to collusion.
Obliged.